So welcome everybody. Welcome to the October 2025 Lunch with Liz. My, how time flies. Today's riveting topic is estate planning for singles. And I know, like in the literature out there, the advertising, I'd said it's estate planning for singles and non-married people. Um, but that's the same thing. Whether you're in a relationship or not in a relationship, if you're not married, you're single under the legal definition. So that is what we're going to talk about today, is estate planning for singles. Um, my name is Liz Moneymaker. I am your host. The first question I generally get asked, or my team gets asked, is that really your last name? And I promise you it is. It was my dad's last name. It was my grandpa's last name. We trace it back to right after the Revolutionary War with some ancestors coming from Germany. So I promise you it's real. I didn't make it up. Besides, when you have a law firm with a Ferrari and a butler, you're definitely going to need a moneymaker. So the firm definitely needs me to stay a moneymaker, right? So what I do is estate planning and probate and trust administration and some elder law as it pertains to Medicaid planning. So people that are needing nursing home care, how do they pay for it? How do they take care of their assets so that they can pay for nursing home care? But today's topic is really focused on the estate planning part and the how to avoid the probate part as well. I started Lunch with Liz many years ago because I found that there was a lot of misinformation on a lot of topics, but especially this one when it comes to what a will does, what a trust does, what it doesn't do. And so I thought, well, what way can I connect with people? And not just put out blogs or do a podcast, but have an opportunity to have conversations so that you can make sure you have clarity on some of these issues. So that's why I started this particular format. And we do it every month, except usually in July. I take July off, but usually every month we have similar or changing topics. Sometimes we have guests. So if you enjoy the format, please take a look at our schedule because we have some pretty good stuff coming up towards the end of the year. How it's going to work. So you see some slides. I'm already sharing my screen with you. I don't always do slides, but I think this particular topic lends itself to some visual learning. So I'm going to do slides. I'm going to try to get through them pretty quickly, like within 20 to 30 minutes, so that we have a good opportunity to have an open forum and discussion. The way the discussion can work is there's a chat function in the Zoom. Feel free to throw your question into that. I will look at it usually after I do go through the slides. You can also come off mute and talk to me, either be on video or off video. It doesn't matter to me. I prefer to see your beautiful face, but if you prefer not to, that's totally fine. The main thing, if I can emphasize anything most in this hour we're going to spend together, is don't leave here if you came with a question and you didn't get an answer. It's important to me that you spent time, you cleared your schedule to be here, that if you have a confusion about something or an understanding about something or a lack of understanding about something that pertains to estate planning for singles, that we get it answered for you today. Okay? So don't be shy. All right. So what is estate planning for singles? Well, really, I mean, I'm going to let you in on a little secret. It's really not different from estate planning for married people. It's the same type of consultation that I do, the same type of analysis of your goals, your concerns, what assets you own, your familial relationships, all of that stuff. The key about single people, though, is the ramifications for not planning are significantly more severe if you don't plan. The outcome can drastically differ from your wishes as a single person, whereas as a married person, and I'm going to highlight this later in our program, but as a married person, there are some defaults that if you're lazy and you don't do planning, that the laws of the state of Florida kind of plan for you in a way that you're probably going to want anyway. That is not the case necessarily for single people. And that's why we put this particular program together to highlight some of those key areas. So now I got to figure out my share screen here. Hold on just a second. All right, here we go. So in general, whether you're married, single, in a relationship, whatever, what type of estate planning documents do I recommend? Do I think that you need? This is the list of them, and we're going to talk about all of them in various detail this afternoon. These include your durable power of attorney for finance, your medical directives, your last will and testament. Maybe you need a living trust, and other options potentially to avoid probate. We're going to talk about all of that today. You're going to get it fast and furious. So I always say, not having a plan is a plan. It just is not necessarily a very good one. The only way that you're going to be able to dictate, especially as a single person, what happens to your money, what happens to your stuff, what happens to your kids, what happens to your pets, is by having a written estate plan. If you don't have one, then somebody's going to be in charge of all of it, and someone's going to get all of it, and it may not be who you want. And this is true whether you are deceased or you're incapacitated. Florida law is going to step in and say, who gets your money, who gets your stuff, and who makes your decisions if you're laying in a hospital bed and you can't make them yourself. And it may not be the person, and oftentimes is not the person that you want. And we'll highlight that today. And when we're talking about incapacity, a lot of people immediately go to, oh, dementia, and I've been, I'm old, and I'm 45 now. I'm not really worried about that right now. But I will tell you in my practice, the vast majority of issues come up in people's 40s and 50s due to strokes, due to car accidents, due to slip and falls and traumatic brain injuries. So I just want to put that in your thinking cap right now, that we're not talking about necessarily age-related issues. These are medical issues that can happen at any age. And I have some examples later that I'm gonna highlight as well. All right. This might be a little hard for you to read. And by the way, we will send these slides out if you want them. Just throw your email in the chat for Vicky, and we'll provide these slides if you decide that you want them in the end. But I'm going to walk you through this slide, because what this slide highlights is what happens if I'm dead, what happens to my stuff, okay? And this is the difference between not having a plan as a married person and not having a plan as a single person. So on the left side of your screen, it's sort of like a question, and then the answer takes you to the next wire diagram. So the decedent is the dead person, right? So does the dead person have a spouse is the first question you ask. And going down the left side, we say yes. And we ask, do they have children? And if we say yes, if those children are the children of the spouses, then that spouse inherits everything. And generally that's what you want when you're married. Not always, believe me, but generally that's what you want. So that's the default. The married people get off easy. There are some issues when the kids are not the kids of the spouse, like it's a second marriage or something. But generally speaking, if you have kids and you have a spouse, that's who your stuff is going to go to if you're married. On the right side of the diagram is if you don't have a spouse, and that's what we're all talking about today, right? So we say, does the deceased person have a spouse? No. Well, do they have children? Yes. So those children then would inherit your estate, would inherit your money, would inherit your property, your condo, your house, your car, your clothes, your memorabilia, whatever you have. And that's true whether the children are estranged from you, whether you haven't talked to them in 20 years, they would inherit your estate. If you don't have children, then it would go to your parents if your parents are still alive. And same scenario, whether you get along with them, whether you're estranged from them, whether you haven't talked to them in 20 years, they would inherit your estate. If you didn't have parents, it would then go to your siblings, if you have siblings. And if you didn't have siblings, then it would spread out between your maternal and paternal side. So think cousins, uncles, second cousins, twice removed. And as a very last resort, it would go to the government. And I've been doing this a little while. Not going to say how long, but I've never seen it go to the government. There's always somebody related to you somewhere out there that's going to get your stuff if you don't have somebody closer in lineage to you to inherit it. So the whole point of this slide is just to show you that the married people kind of have a default that they would most likely go to anyway, right? Spouse, kids. Whereas if you are single, you might not want your children or your parents or your siblings to inherit. It might be your significant other. It might be your best friend. It might be a charity. But none of that's going to happen unless you put it in writing. It's going to go by this chart, by what Florida law says. So this is why planning is critical. It lets you provide, make sure that you can put into writing who your chosen people are. The chosen people to get your stuff. And I've highlighted and put in red chosen on this slide as many times as I could, because that's the key. If you don't choose, Florida is choosing for you, which is why planning for singles is so critical. Okay. So when I am probably any estate planning attorney, when I'm having my initial consultation with a new client, and those for me anyway are complimentary, so that we can see if we're a good fit, make sure I understand what you need, and that's something that I can help you with. We talk about all of these bullet points, whether you're married, whether you have children, whether you're estranged and you're disinheriting your children or your siblings or your parents or somebody like that, whether you have minor children, whether your children or other beneficiaries have drug issues, or maybe they have a special need like Down syndrome or autism, or other types of cognitive issues where they're never going to be able to care for themselves. So we have to figure out a plan on how to do that if you're no longer around to do that for them. A lot of my practice is planning for pets, because for a lot of us, our pets are our children. And if something happens to us, especially if we're single, like who knows that the pets are there? Who knows who the vet is? Who knows how to get into the house or the condo or the apartment? So it's having the forethought to plan for these people that are going to jump in and make these decisions and care for you in the event that you're incapacitated or you've passed away. Other issues we talk about are whether you have assets in other states or other countries, and of course, whether you're going to pay Uncle Sam when you pass away. These are just some of the things that we talk about when we have that initial consultation, so that we can then know what types of documents, what types of plan do we need to put together for you to accomplish your goal? What is it that you want to make sure happens if you have a stroke and are incapacitated in a hospital, or you have passed on to the great beyond and you want to make sure that your wishes are followed? So some of the documents, and if you remember my first slide, and I told you I was going to go fast to the slides so that we could get to the fun part, which was just us talking. But the first slide, we talked about the documents that I recommend everyone have. And one of those documents is the last will and testament. The last will and testament is only effective at death, right? It only gets filed with the court and becomes powerful after somebody dies. It's an important document because it names guardian of minor children if you have them. It names your executor, and your executor is the only one that can deal with, for example, the IRS or the insurance company, or sue on your behalf after you've passed away. It has a lot of rules about how it has to be written, how it has to be signed and witnessed and notarized. I see a lot of wills in my practice in probate administration that are not valid because people tend to try to do it themselves and they don't follow Florida law on what to do. So then it becomes like they didn't have a will at all, which is unfortunate. The highlighted part there, I'm going to point out now, I'm going to talk more about it later, but I do want to plant a seed. If you are relying on a will to transfer your assets at death, the will has to be probated, meaning there has to be a court case. So many people think, well, I have a will, so I'm going to avoid probate. Does not work that way. If you're relying on the will to transfer your assets at death, there will have to be a probate. Now, note that I keep saying if you're relying on the will to transfer assets, because we're going to talk about that more later. But think about somebody that you know that has passed away. They probably had other ways that their assets passed, right? They had joint accounts, so the account went to the other joint owner. They had a beneficiary on their life insurance or a beneficiary on their IRA. And so therefore, those accounts went to those beneficiaries. Didn't matter if there was a will or not. That's where that money went. So that's why I say if you're relying on the will to do it, because there's a lot of ways we can transfer assets at death that have nothing to do with the will and nothing to do with the trust. And I'm going to talk more about those in a few slides. But I wanted to plant that little seed because sometimes it doesn't really make sense to people. Okay. A trust is also something that I sometimes recommend to people. I probably don't recommend it as much as some attorneys because my philosophy is, what is the simplest way to accomplish your goal? And typically it is the most cost-effective way to accomplish your goal. And it tends not to be a trust. Now, sometimes I got complex clients, I'll admit it. You know, they have property in another state, they have special needs children, they have minor children, and there's good reasons that the only way we can accomplish their goal is through a trust. But for a lot of people, that's not the case. So my analogy on a trust, and if you've ever heard me talk about them, this is the analogy I use to every client and at every lunch with Liz where I talk about trust, is I like to think of a trust like a bucket. So let's take me, for example. Let's say I own a condominium. I own a couple bank accounts. I own a brokerage account, an investment account somewhere. So all of these accounts are in my name. So if I create a trust like a bucket and I call it Liz's bucket, then I retitle all those assets as Liz's bucket. So now they're in the bucket and the bucket owns them. And the reason why that's important is because the bucket doesn't die when I die. It stays alive. And the person I put in charge of the bucket then follows my instructions, which is the trust language, and then takes things out of the bucket and gives them to the people that I want to have them after I pass. Trust is a great tool. I write them all the time, but not everybody needs them to accomplish their goals, for sure. And we'll talk about that next. So there are a myriad of ways that we can avoid probate, whether we're single or married, as without a trust or without a complex estate plan. So I'm going to go through some of these now. One is joint ownership. So think of joint ownership on a checking account, for example, or a brokerage account, or putting someone's name on a deed. This can avoid probate, but it also, and I really want to emphasize this, can cause major problems. This is the least recommended route that you would use to avoid probate as a single person. I'm going to tell you why. When you think about things like bank accounts, once you put a joint owner on them, that joint owner has legal rights to that account and they can take everything out, wipe it clean. There's no legal recourse for you. There may be some civil litigation recourse for you, but not criminal recourse for you. Additionally, that joint owner, so think about mom, right? Mom puts son on the bank account because she thinks it's going to be easier to write checks. Well, guess what? If that son files for bankruptcy, that is son's asset. right? That bank account that was mom's. Son gets into a car accident and he doesn't have the insurance coverage to cover the accident. Guess what assets are son's? It's that mom account. So I tell my clients all the time, just be very, very careful when it comes to just simply adding somebody on an account. Deeds are even more problematic because you have gift tax issues, you have capital gains tax issues. I'm not a tax expert. I always refer people out to a CPA to talk about these things. But the best example I can give you is, let's say mom buys her house for $100,000 and she um, it and the son then inherits it through a will or a trust or however he does. He inherits it. And at the time of her death, it's worth $1 million, right? Because he inherited, he now takes it at that $1 million. So if he goes to sell it, he only pays gains on anything over $1 million. Whereas if she had added him to the deed before she died, he would not get that step up in basis and he would have to pay gain on all of it. So there's significant issues there. There's another issue when it comes to Medicaid planning. Let's say mom needed nursing home care and now she's gifted her house. That's problematic. It can keep her from getting Medicaid to pay for nursing home care. So big red flag. It's one of the big things to take away here is joint ownership. Be very careful. Talk to somebody first because you could really mess things up down the line by trying to take what seems like an easy way to avoid probate. Much better course of action in most cases is to do pay on death designations for bank accounts. So that's a form at the bank. You go fill it out. It's essentially just putting a beneficiary on your checking, your savings, your money market. Same thing with transfer on death designations. Those are on things like certificates of deposit and brokerage accounts. It's a way to transfer those assets to a beneficiary or multiple beneficiaries at death. All the beneficiary has to do is take the death certificate to the financial institution and file a claim for the money. No probate needed at all. Much better option than the joint ownership if you're worried about bankruptcy or other legal actions of the joint owner, for sure. Other types of beneficiary designations we've already kind of talked about, but things on like IRAs, 401ks, life insurance policies, annuities, all of those things can have beneficiaries placed on them. And if you use the beneficiary as your estate, you're guaranteeing probate. So you want to make sure that the beneficiary is a person or a charity or something like that to ensure that you avoid probate if you're using those types of tools. The last thing there is something a lot of people haven't heard of, but it is an awesome estate planning tool that we have in Florida, and it's called an enhanced life estate deed. The slang term is a lady bird deed. Without getting too complex into real estate law, it essentially lets you put a beneficiary on the deed. We replace your current deed with a deed that says, I'm Liz, I'm deeding my condominium to myself for the rest of my life. I can sell it, I can finance it, I can do whatever I want to with it. But upon my death, it goes to whomever it goes to. And you avoid probate that way. So for a lot of clients, and I'm going to move on to the next slide, like John here, it's a way to avoid probate. So let's say we have a client, John, he owns a house, he has checking and savings, he's got brokerage, he's got retirement accounts, no spouse, no children. He's a single guy. So depending on what his goals are and who his beneficiaries are, we can avoid probate by putting a beneficiary on the house using the ladybird deed. We can do pay on death designations on his checking and savings, transfer on death designation on his brokerage account, and beneficiary designations for his retirement and life insurance. We'd still do the will because the will would take care of his car, his personal effects, his pets if he had them, and name the executor. But his big items that would have had to have been probated would be taken care of in this manner. Not saying this works for everyone, but this is a simple way to avoid probate without getting into complex estate planning. All right, moving on. I also have a few more slides and then we'll open it up for questions and commentary. So we've talked about what happens to our stuff when we die, what types of tools that we have, like the will and the trust and ladybird deeds and beneficiary type accounts for things when we pass away. I want to take just a few minutes now and talk about incapacity planning because that is critical as well for single people. Well, everybody really. Um, so there's two main documents we're talking about here. We're talking about your power of attorney for finances, and then on the next slide, we're going to talk about your medical directives. So a durable power of attorney for finances lets someone step into your shoes to pay your bills, pay your mortgage, deal with insurance, deal with the IRS, deal with the business if you have a business, help coordinate long-term care planning. Durable means that it stays in effect even if you become incapacitated, which is the whole point of having the durable power of attorney is for if you become incapacitated, right? That's when you want someone to be able to pay your bills, make decisions for you financially, potentially have to sell your house to have money for your care, that type of thing. And I mentioned that earlier in the program about, people think, oh, old age when this happens. But I have two clients just in the last year who were in their 40s. One was 47, had a stroke. He was married, but his wife still didn't have power of attorney, so wasn't able to make decisions without going to a judge. And another one was 40, and he was down in Sarasota, and he was blinded by the sun on his way to work. Car accident, traumatic brain injury. Single guy. His mom and sister lived in Sarasota as well, but they didn't have access to his apartment. They didn't know his bills. They weren't able to get any of that until they went to court with a judge and got authority to do that. Had both of those situations had a power of attorney, they could have taken care of things a lot easier and a lot more less expensive for sure. The next document, I kind of wrap it all into one, medical directives, but it's really two. It's living will and a healthcare surrogate. The living will is what you use to say what you want in the event you can't make decisions for yourself medically. Do you want to be kept alive artificially forever? Do you want the plug pulled? That sort of thing. What kind of care do you want if you have dementia, for example? It also lets you name someone who can make decisions for you. Now, for the power of attorney, there's no hierarchy in the statute that says who gets to make decisions for you if you don't designate someone. But in the healthcare surrogate statute, there is, and it typically is a spouse if you have one, adult children if you have them, and then parents. So those may not be the people that you want to be making those medical decisions for you as a single person or as a person in a relationship but not married. But there's nothing in the statute for a best friend or for a significant other. So you'd want to make sure that you have that in writing if you have someone other than parents or children or siblings to make those medical decisions. Without having the power of attorney, the living will, all that set up, your family or your friends, loved ones are then forced to go to court and create a guardianship. And that's what happened in the two cases I talked about a little bit ago with my 40-something-year-old clients. I had another case a few years ago in Sarasota where these didn't happen in Sarasota with long-term companions, man and woman, and he took care of her as her dementia progressed. But then the family decided that they wanted to take care of her, mainly because she had quite a bit of money. She hadn't talked to her family. They lived up in South Dakota for about 20 years. The family filed for guardianship, and they ultimately won. They took over guardianship rather than her longtime companion because the court tends to go with family over people that aren't married. And that was really sad. Sad for the man, sad for the community that they belong to, and sad for her, even though she didn't really know what was going on with her anymore. So I'm gonna get out of these slides now and stop sharing. There we go. All right. And I'm just gonna look in the chat to see if we have anything other than the slide requests, and we don't, I don't think. So I'm going to summarize while I wait to see if you guys have any specific questions or comments that you want to bring up. So the main thing is there's not a significant difference in planning when it comes to married people or single people. The difference is the ramifications if single people don't. The defaults are not the same as for a married person necessarily. You typically think a married person wants it to go to their spouse or their children. Um, Whereas a single person, it may not be parents, it may not be siblings that you want your assets to go to or that you want to make decisions for you. So that's why it's important for singles to put your plan on paper and get it on paper in the legal way so that it gets to be enforceable in the event you become incapacitated or pass away. With that, I'm going to pause, just take a quick drink of water. And if anyone has questions, you want to throw them in the chat, or you want to come off mute and just holler at me. Either way is good to me.
I have a question. If you could repeat what you said about if when the son inherits the mother's house and when he pays taxes, if it's on the what she bought it for or the sales price, is that when he's on the deed or not on the deed?
So the best thing to happen is to inherit the property after mom dies, because then you get her step up in basis. And
Okay.
now you're only paying on the date of death value, anything over that.
So not to be on the deed is the best.
Correct. Correct.
Okay. Okay. Thank you.
Mm-hmm. Good question.
Hi, Kim here. You had
Hey, Chris.
briefly mentioned in that same example impacts on Medicaid and eligibility. Can you go into depth a little bit more about that?
A little bit. I do a lunch with Liz on Medicaid planning and gifting and how that impacts, but really quickly. So Medicaid in Florida, and just so everyone knows, Medicaid is implemented differently in every state. Every state has their own state rules, even though it's a federal program. Florida has a 5-year look back. And what that means is within 5 years from the time that you're applying for Medicaid, if you have gifted things to other people, Medicaid potentially can and typically does say that you can't be approved for Medicaid unless you cure the gifting. So, for example, I had clients who had given their son property, and it was only a few years prior to them needing Medicaid. So what the son then had to do was then buy the property so that the parents would be able to get on Medicaid. He was able to do that, but a lot of people aren't, they don't have the funds to be able to do that. And unfortunately, that then would create a period of time in which the parents wouldn't be able to get on Medicaid because they had gifted this amount of money. Or this property worth a certain amount of money. It's a little bit complicated to talk about how long they would be penalized and how long they wouldn't be able to get on Medicaid. Just suffice it to say that giving things away, can have a very negative impact on being able to get on Medicaid later within that 5-year period.
Thank you.
Welcome. Any other questions? Did anything I say not make sense? You want me to kind of go over it again, like, the will thing, and other ways to avoid probate? Okay.
At what point would you recommend a client have a trust?
So, do you remember the slide that I put up with which said like, let me just pull it up here. So like it was like, what are their goals? And I talked about how when I see a client, we're going to talk about everything on that list pretty holistically. Like, do they own property in another state? Do they have minor children? Do they have special needs children? So it ultimately depends on what their goals are. So let's say I have a client that said, Liz, my goal is I want to avoid probate, but I have property in North Carolina. I'm like, okay, well, because you have property in North Carolina, which does not have a ladybird deed option, we would need to create a trust so that we could put the North Carolina property into your trust so that we could avoid probate both for your North Carolina property and all of your Florida assets. That's an example. Another example would be, let's say you're a client and you have minor children, and if you died while the kids were still young, you would want to make sure that they just didn't get a lump sum. So the trust then would be the way for you to control from the grave, because remember, your bucket lives on after you die. And your bucket instructions could say, hey, don't give Junior his money till he's 30, for example. So that's another reason you would have a trust. So again, it comes down to what are your goals? What are your assets? What tools can I use to accomplish your goals with the assets that you have? So there could be a million reasons to have a trust, depending on what your goals are and what your asset mix is. So I think Deb raised her hand. Go ahead, Deb.
Yeah, you have a power of attorney for financing. So do you need a separate power of attorney for every different bank account that you have?
No, it's just one.
Okay.
Yeah. It's just a power of attorney for finances is all it is. So it covers banking, investments, real estate, all that stuff, all in one document.
Okay, and do you give that ahead of time, a copy of that, let's say, to your bank, or does that person that has power of attorney just take it into the bank when they need to pay your bill? So,
Either way, proactiveness works best if it's on file with your bank and it's already gone through legal. If you wait till you're incapacitated and now your agent is going to the bank, it's going to be a few days to a week for that power of attorney to make it through the legal department and get approved. And then, what if there's something wrong with it? Like, what if you forgot to initial something, or something like that? Well, now it's too late for you to fix it. Whereas if you were proactive and had gone in to put it on the account, then then it's already set. Caveat of that though is, and I do this as a case by case basis, so I'm talking to, like, if you are naming your, best friend of 50 years and you have no issues whatsoever, then maybe going ahead and putting them on the account of power of attorney is great. But if you just met, your handyman last week and now you decided you're going to make him the power of attorney, I would strongly encourage you, one, not to do that, but two, not to take the power of attorney to the bank, because you hopefully probably will find someone better to name as your agent on your power of attorney. So that's something I talk to each client about. It's a case by case basis as to what really makes sense.
thank you.
Yeah. I think there was a question in the chat, so let me pull that up real quick. I don't see one. Wait, hold on. All right, I am a legal resident of Florida, and I have everything on POD, TOD. So that's pay on death, transfer on death, what we all were talking about a little bit earlier. My Florida home has a ladybird deed. See, this person didn't even need to come here. Just kidding. But I also own a summer home in Minnesota. I have that home on a TOD, which Minnesota allows. My brother is my chosen person. Okay. If something happens to me while I am summering in Minnesota, are my Florida power of attorney and healthcare surrogate valid in Minnesota for my brother to use? That's a great question because we have a lot of snowbirder people in Florida. So I can only answer it from the Florida perspective because I'm not licensed in Minnesota, but I can tell you that in Florida, we recognize documents that were legally done in another state. So if the transverse occurred and you had the Minnesota documents, they would be recognized in Florida. I'm going to presume that Minnesota would be the same, but don't rely on me because I didn't go to law school there. I didn't take their bar exam. So that's something you probably would want to double check there. I will tell you that oftentimes when I have people that are always going to be here for 6 months, there for 6 months, I'll recommend that they do 2 sets and that the 2 sets don't revoke the other set so that you have a Florida one while you're here and you have a Minnesota one while you're there. And that could be helpful too if you have 2 different people. Like if you had one person when you're in one place and another person and when you're in another place. The key there is most documents revoke any other documents. So you would want to make sure that they jived with each other and they referenced each other with that. So long story short, for that question about the Minnesota person is talk to a Minnesota attorney to make sure that my guess would be yes, but don't rely on that because I'm not licensed there. Next question was, where do you store these documents if you live alone? Great question. I recommend in Florida that you have them in a fireproof box or a fireproof safe, also a flood-proof area, so not in your basement. And that somebody knows how to access that, whether it's, ideally it's the agent that's going to be carrying out your wishes. But they just need to know where it is. I'll be honest, mine's on a bookshelf and my agent knows that it's there and where to find it. So you don't really have to get complex about it. Definitely have electronic copies somewhere as well. Like if you work with me, you get electronic copies once you sign everything, and then we keep electronic copies in our cloud, our secure client portal for you as well, so you can access them at any time. So the main thing for that question, Joyce, is that someone knows where they are. I don't recommend a safe deposit box at all because once you're gone, we need a court order to get into that safe deposit box unless the safe deposit box is owned by the trust. So safe deposit boxes for your wills, bad idea. So if that didn't answer your question, let me know. But that was my down and dirty for it. Other questions? A lot of what I was talking about was a lot of, I know, doom and gloom. Like if you don't get this in writing, terrible things are going to happen. And they might not. Maybe you want everything to go to your parents if something happened to you, or maybe you want it to go to your siblings if something happened to you. But the main thing is if you become incapacitated, they don't have authority to act on your behalf, and they would have to spend, I don't do guardianships anymore. I haven't for about 5 years, but when I did, it was like $10,000. And powers of attorney are a lot cheaper than that. So to me, I think they're the one of the most, if not the most important document to have if you otherwise don't care what happens to your stuff. I'm gonna go to Deb first, and then I'll address the questions in the chat.
Thank you. Can you speak a little bit more about the Lady Bird document?
Yeah, absolutely. And Vicky, would you mind throwing our blog post in the chat too, so people can access that if they want? So a Lady Bird deed is a life estate deed. But unlike a regular life estate deed where you just have an interest in it at during your lifetime and you can't undo that interest, the Ladybird deed says, I own the home, I can sell the home, I can refinance the home, I can do whatever I want to with it, but upon my death, it automatically passes to whomever. It could be a person or it could be several people. The cons of a Ladybird deed, the main one is that we can't do contingency planning with the Ladybird deed. So we can't say it goes to Johnny, but if Johnny's gone, then it goes to Sammy. So that is a limitation of the Ladybird deed. The other con of the Ladybird deed is a lot of title companies, closing companies would then want the people that you named as beneficiaries to sign off on a sale or sign off on a refinance or something like that. There's no statutory requirement. There's nothing in the law that says that, but a lot of them will do that to cross their T's and dot their I's, which could be problematic. Let's say that you were leaving it to a partner, and then there was a bad falling out with the partner, and now he or she's not signing off. That could be problematic.
So
So
where does it go? Let's assume that you've identified who it's going to take the ownership and they have died.
I'm sorry, say that again.
Um, you said that if the person that you're leaving it to has passed away, what then happens to it?
Yeah, so if you're what they call the remainderman, but I'll just use the term beneficiary because that makes more sense to people. If your beneficiary dies and you don't update the ladybird deed, then it goes to that person's estate. So
Okay.
then it could be, it could end up going to someone that you didn't want it to go to because, um, who knows what their estate plan said.
Thanks.
Yeah. So it's a great tool, but it does have its limitations. So again, it's one of those things when meeting with clients, we talk about what are your goals? Your goals to avoid probate? Well, this tool can get you there, but it can't do everything. It's not a panacea for all your planning purposes. I'm going to go back up to the chat a little bit. Okay, I have a mobile home on leased land. It doesn't qualify for a ladybird deed. Correct. It does not qualify for a ladybird deed. Um, there's some argument about a mobile home could be homestead property, but I'm not a real estate attorney. So, Deb, if you have questions about that, I do have a very good real estate attorney I can put you in touch with. So if you want that, let Vicky know and we'll send you that contact information. She would be a better source of information for you on the best way to handle the mobile home. I can put mobile homes in trusts, and I have done that sometimes, but just depends on really what the value of the estate is overall, and then what the goals are of the client for sure. Joyce, putting in trust and safe deposit works. I'm not sure what that means, Joyce. So if you could just clarify that, that would be great. And I am not licensed in Ohio, and I don't know anyone who litigates in Ohio. Sorry about that. Another question that's just to me just says, can we give our documents to our agent ahead of time? Absolutely. You can. And again, this is something I talk to each client about is if you do that and you change your mind about how you want to distribute things, who your agent is, now you've got this copy of a document out there. So which could be confusing when you pass away, right? Or when you become incapacitated. So I'm not saying don't do it. It's just a conversation that we have as to what makes the most sense. If I have clients in their 30s, and we don't know when we're going to get called up to the great beyond, right? But statistically speaking, they're going to live a long time. The likelihood is they're going to make multiple changes to their documents. So maybe it's not a good idea to start having multiple copies out there. Whereas if I have, a 98-year-old and, we're in hospice redoing his stuff, that's appropriate that, everybody, all his agents have that. And those are two real big extremes, and most people fall somewhere in the middle. I think the main thing I'm saying is there's no right or wrong answer. It just depends on your particular situation. Let me see if I can see any other questions. Okay, you mentioned not putting documents in safe deposit unless in the trust. That helps as an additional option. Include the safe deposit in the trust, which I hadn't considered. If you have a trust and you have a trust-based plan and you have a safe deposit box, your safe deposit box needs to be in the trust, needs to be owned by the trust. Okay. I just had it this week. If I don't have it every week, I have it every other week where a family comes in, they have a trust, and they want me to help them administer the trust, meaning someone has passed away and now we need to distribute. I swear on everything that is worth anything that once every 2 weeks, it is a trust that has nothing in it. It is an empty bucket. And this one had been amended like 4 times by another attorney, but the properties were never deeded into the trust. The bank accounts were never moved into the trust. The investment accounts were never moved into the trust. So now we have to not only administer the trust, but we have to get the stuff in the trust. So we have to open up a probate. So everything this client went through to create the trust and have this elaborate plan is for naught, because we have to go through the probate process anyway for it to get into the trust. So if you have a trust, you need to put stuff in the trust. That is, otherwise it's a waste of time and money to have a trust. And a lot of times people go online and they'll print off a trust, and the trust in itself will talk about all the stuff they own, but they don't take that next step to actually retitle assets into the trust name. And so it's a worthless piece of paper. Anyway, done with my soapbox on that. No empty bucket. Got it. Yeah. Thank you, Joyce. Yeah. That's the best advice I can give. If you have a bucket. If you don't have a bucket, you just want to make sure that you have beneficiaries on all the accounts, and that you have either you have another way for it to pass when you die, or you understand that it's going to go through probate and you have the will done in the manner in which that you want, so that your heirs can then easily go through probate and distribute your assets. Okay. All right. Well, thanks for that. Okay. We're about 7 minutes left. If you have gotten everything you wanted to go, you don't hurt my feelings. I know everyone's got things to do. Oh, we have another question. I have a trust. The properties and my accounts are in the trust. What is the most efficient way, fastest for my agent to access funds to pay funeral expenses and ongoing expenses? I live between Florida and Maine, and my agent resides in Utah. So by agent, I'm assuming you mean your successor trustee. So it's going to depend on your trust language. Generally speaking, like when I create a trust, the language in there gives your successor trustee authority to access any of your funds. And the first priority is to pay funeral expenses and valid debts. So it's really going to depend on your trust language. And then they access whatever funds that you have to pay those debts. To me, for funeral expenses, the best thing to do is have prepaid funeral expenses. You're going to pay a lot less, and you're going to get what you want versus what people think that you want. Like my mom passed away this summer. We didn't have any idea what she may have wanted. We knew she wanted to be cremated, so that was good. But other than that, we didn't know. So, and shame on us, but we all know we're going to go at some point, and that is a great gift to give your family, friends, loved ones, is making these decisions ahead of time and just prepaying for it all. You pay a lot less too, for sure. Allison, does she have to go to an institution in person? Generally not. Generally, all of that can be done, electronically these days. Really depends on your financial institution. Your financial institution, since your trust is fully funded, they should have your trust or your certificate of trust on file. They should know who your successor trustee is. So they'll just have to file whatever paperwork for assuming the role as trustee, and then they'll have access to all your accounts. Welcome. Okay. All right. Don't think I've missed anything. If I have, you put something in the chat and I didn't see it, just tell me to go look again. But I did a quick looky-loo and I didn't see it. I really appreciate you guys being on here. You're a great inquisitive group. Moral of the story is not having a plan is a plan. It's just not a very good one. All right. With that, we will see you. Hey, next month, I have a special guest. I have a professional fiduciary on who's going to talk about 2 things about being an executor and an agent. So an executor on a will, a trustee on a trust, or an agent on a power of attorney. Two scenarios. the things that you might need to do if you're called upon to have that role, as well as some things you should think about when choosing those agents. So if that's of interest to you, that will be our November lunch with Liz with special guest Kathleen Seedy. Oh, Deb, I missed your question. Tracy, I just like the National Cremation Society, to be honest with you, because they go everywhere. And they've got a lot of different plan hierarchy, for different cost levels. So that's generally who I recommend. And if your family, then I've got, a particular contact I like to use as well. All right, Deb, I'm looking for your question, Deb. Um, I don't see, I thought I answered the one on the mobile home, Deb. So if there's
No,
a different,
I don't know. I'm really a neophyte when it comes to Zoom,
yeah,
but if is an out-of-state will valid in Florida?
yeah. Well, yes, as long as the will was done in accordance with the laws of the state in which it was written and executed. So let's say you have a Georgia will. As long as would be valid in Georgia, it will be valid in Florida.
Okay, great.
Yeah.
Thanks.
Yeah. So I have a lot of people that come in to see me like, oh, I moved to Florida. I need to update my documents. And sometimes they do need to because there's other changes in their life. But just because you move to Florida doesn't mean that all your other documents aren't valid.
Great.
Yeah. All right. Well, I'm going to let y'all go. Hope to see a lot of you back in November for that special guest talking about all the things you might need to know if you're ever a agent and a power of attorney or a executor under a will or a trustee in a trust, or gosh, what do I need to think about to select that person? Again, appreciate you guys being here. It's been a lot of fun and have a great October. Happy Halloween.